Yesterday, I did 2 sessions on the Supreme Court's decision on Endrew F. v. Douglas County School District, which was decided March 22nd on 2017 by the U.S. Supreme Court. Of course, that it's a major decision. It will affect special education in many ways. And one way that it's going to really affect special education is how we as IEP team members and as special ed directors developed individualized education programs in our case conference committee. And so that's what I'm going to talk about today, is what it means for us as case conference committee members, what it means for us in developing IEPs. And I'm going to go back and review just a little tiny bit and then go on with how I believe this case will affect us. But first off, what I want to mention is, as I talked about yesterday, this decision is, the heart of this decision is what is a free appropriate public education. Now, a free appropriate public education, or a FAPE, as I'll probably call it most of the time, is our primary charge as special education teachers, as special ed directors, is to ensure that the students we serve, we develop IEPs that confer a free appropriate public education. Because essentially a free appropriate public education is what we write in the IEP. Now, this is the way the federal government in 1975 defined FAPE. It's the way the idea in Article 7 still defined FAPE. The words are a little different in Article 7, although they essentially mean the same thing. FAPE means it's an education or a special education and related services are provided at public expense, meet the standards of the state educational agency, and essentially that means that when a state's rights they provide to youngsters with disabilities exceeds the federal rights, you have to follow the state law. For example, in Indiana, transition services begin at age 14. The federal law says transition services begin at age 16. But because you are in Indiana, you have to follow Indiana law. Now, on the other hand, Indiana couldn't offer less than the IDEA does. So, whereas the IDEA requires that one group of students with disabilities who are eligible for service under the IDEA as youngsters are youngsters with emotional behavioral disorders. Now, Indiana, for example, could not say that, well, youngsters with emotional behavioral disorders are not eligible for services in Indiana. They can only do more than the federal government says they can do. They can't do less. And you have to follow them when they say more. Okay, it includes preschool, elementary, or secondary education. And here's the really important thing, and why we're going to be talking about this today, is an IEP, a FAPE is provided in conformity with the individualized education program. In other words, the IEP becomes the blueprint of a FAPE. Of every child's FAPE is contained in that document, in the IEP. Now, this case, Endrew F. v. Douglas County School District, went all the way to the United States Supreme Court. But you know where it started? It started the IEP team in an IEP meeting in a school in Denver, Colorado. And it wound up being decided in the Supreme Court. And what was at basis is the child's IEP. The child's name was Endrew. His parents called him Drew. He had an IEP that was he had been in the Douglas County School District in Colorado from preschool through 4th grade. In 4th grade, his parents believed the IEP no longer provided Drew with a FAPE, or a free appropriate public education. Now, there was for a number of reasons for that. For one, his academic achievement had stalled. Number two, his behavior was getting out of control, and there was no good behavioral programming in the IEP. So, as is their right, under IDEA, they requested a due process hearing, contending that their IEP did not provide FAPE. Now, of course, that is a right parents have or school districts have under the idea is if there's a disagreement that cannot be settled in the IEP process, either party can apply for a due process hearing. The loser, the person that loses at the due process hearing, can then file appeal with either federal or state court. And the first appeal goes to the district court. The second appeal, if there's an appeal, goes to the next higher court, which is the U.S. Court of Appeals. And finally, it could even be appealed to the highest court in the land, which is the U.S. Supreme Court, which has happened probably 12, 13 times. Since 1975, since the passage of the Education for All Handicapped Children Act, which now, of course, we call the IDEA as of 1990, and that's what happened in Endrew. The parents disagreed with the IEP, and they said this IEP does not provide our child with a FAPE. They could not collaborate with the school district personnel to develop what they believe is appropriate IEP, so they asked for a due process hearing. They lost at the due process hearing, where the hearing officer ruled that the school had provided an appropriate education. Then they appealed to the Circuit Court of Appeals, or the district court, which upheld the hearing officer, saying the school had delivered a FAPE. They appealed to the U.S. Circuit Court of Appeals for the 10th Circuit, which is it's a large circuit, the 10th Circuit, and they also upheld the lower court decision and the hearing officer saying the school had provided FAPE. So undaunted, the parents appealed to the U.S. Supreme Court. And they decided to hear the case, which is a pretty big deal because they only hear, out of 8,000, 9,000 cases referred to the Supreme Court a year, they'll maybe hear 80. So not a lot. So it's a big deal when the Supreme Court hears the case, especially because that becomes the law of the land. And that is exactly what happened in Endrew. And Endrew was actually the second free appropriate public education case heard by the Supreme Court. The first was the Rowley case, Board of Henrik Hudson School District v. Rowley. And essentially what the Supreme Court said in these two cases is this is the proper way to rule on a FAPE case. For hearing officers, the lower courts, you have to, if there's a contention by parents that a school district had not offered a FAPE or conferred a FAPE, parents, the hearing officers or the judges have to ask two questions and answer two questions. And these are the two questions. We call this the Rowley-Endrew test. The first question a hearing officer will ask is the development of an IEP. In the development of IEP, did the school district follow the procedures of the law? Did they comply with the procedures of the law? And if yes, they move to the second part, or the second question. Is the IEP developed through the IDEA's procedures reasonably calculated to enable the child to make progress that is appropriate in light of his or her circumstances? Now, the big thing to understand is every case ever that's been heard on FAPE boils down to what happened in that case conference committee or in the IEP meeting. Every one of them. I should say now, I am a due process, in addition to working at the University of South Carolina, I'm also a due process hearing officer. I've been a hearing officer in California since 2000, South Carolina since 2000, and then a couple of years ago, the attorney for the State Department asked me to become a state review officer. We have a system in South Carolina. It's not like your system here. In your system here, if a parent disagrees with the IEP and says, you did not provide a free appropriate public education in this IEP, I want to file for a due process hearing, it goes before a hearing officer or a panel of hearing officers at the state level, and they make a ruling. Then the parent or the school could then appeal to the federal court system, and so on and so on. Now, in South Carolina, it's a little different. An appeal of an IEP first goes to the impartial hearing officer at the local agency level, which I used to do, where a school district would ask me as an impartial hearing officer, will you come in and hear this case? And I would, and there'd be lawyers on both sides, and teachers would be examined and cross-examined, there'd be evidence. But now what I do is I review decisions by local hearing officers. And in fact, as is the case with all states, the vast majority of decisions that we have to render regard an IEP, the IEPs. Because parents contend, this IEP does not provide FAPE, and the school contends, oh yes, it does provide FAPE. And that's what the grist is of probably about 95% of all hearings and cases in the United States. And this is why IEP is so important. As I said, it defines what an individual FAPE is for a child. So every case boils down to the IEP. And this is what Endrew F says about the IEP. It's through the IEP that the free, appropriate public education required by the IDEA is tailored to the unique needs of the child. And because it is the blueprint of a FAPE, failing to properly develop and implement an IEP may render an entire special ed program invalid in the eyes of a hearing officer in court. So remember, there's two things. The Supreme Court said, if I as a hearing officer have to hear a case on FAPE, I have to look at the IEP. Both parties, both attorneys will be arguing about the IEP. And there's two important things we have to understand. The first test is the procedural test. As a hearing officer, I would say, did the school districts follow the procedures of the law? That's not all that difficult, because Article 7, or the IDEA, Article 7 being the state version of the Indiana state version of the IDEA, has a number of procedures we have to follow. For example, if we want to assess a child, we have to get informed consent. We have to get the parents signed on the dotted line. If we want to place a child, we have to get parent consent. If we are going to have a case conference committee, there are certain people we have to have there, the law says. Same with the IDEA. The IEP we develop has to have certain components. These are all procedures that we have to follow. That's the first thing a hearing officer will look at. But the second thing is they're going to look at the substance. And that was what the Endrew case was about. Is this IEP reasonably calculated to enable a child to progress appropriately in light of his or her circumstances? And there is one more concept that I want to talk about too. So in essence, we have three basic concepts that we as IEP team members, as special ed directors, we need to or as LEA reps, we need to understand about what the IDEA requires. So first are these procedural requirements that essentially say we've got to follow what Article 7 says we need to do in setting up the IEP meeting. And all these safeguards like written consent and having appropriate members on the IEP team, really what they're there to do is they're designed to protect the rights of students with disabilities and their parents by requiring that the school district takes certain actions that involve the parents in the IEP process. So essentially, the procedural requirements represent the how and the when of IDEA. It's what Article 7 says, when we have to do things and how we have to do them. And essentially what Rowley said in the very first part of the test, as a hearing officer, as a judge, what we have to do is determine, did the school district comply with these procedures? That's why, oftentimes, I remember I was a teacher in 16 years for Minnesota, and I remember many times at the beginning of the year, the first thing we have is a session with a special ed director where she talks about procedures. This is what you have to do before you do the IEP. And this, during the IEP, this is what has to be done. And these procedures are very, very important that we follow them, because sometimes violating these procedures in and of themselves can lead to a ruling that the school district did not provide FAPE. Now, in the Individuals with Disabilities Education Act of 2004, they added a little section to the procedural safeguards of the idea that has been kind of referred to as the norm, no harm, no foul part of procedural safeguards. And essentially what that says is procedural safeguards are really important and must always be followed, but if we don't actually follow them exactly, that may not lead to us finding against a school district that they had not provided FAPE. But some procedural safeguards are really bad. And if we commit these in the IEP or case conference committee, we're quite probably developing an IEP that does not confer FAPE or would be illegal under the idea. And here's what Congress said. If we commit a procedural violation that impedes a student's right to a free, appropriate public education or causes a deprivation of educational benefits, that is so serious a mistake, a procedural mistake, that could result in a finding, would likely result in a finding that the school district did not provide FAPE. Let me give you an example. So there's a procedure in the assessment section of Article 7 and in the idea that says we have to address all of a student's needs in the assessment. Okay, let's just say we kind of violate the procedures because, and this has happened quite frequently, a school district has not addressed all of a student's needs during the assessment. And I can give you an example of that. I just had a case probably about 5 or 6 months ago in which I was ruling on a due process hearings officer's. The parents had alleged that the school district had failed to provide FAPE. And one of the issues had to do with the assessment. And sure enough, the child had a significant communication problem. The school district had failed, even though they're supposed to address all those students' needs, had procedurally failed to assess communication. That was a procedural mistake. But because of that procedural mistake, they wrote an IEP that didn't address communication, which was a need. Therefore, the entire IEP was bad. It was declared invalid, that it violated the idea. The school district had violated the law because of that serious procedural mistake. But the most serious procedural mistake of all is if the procedural mistake you make significantly impedes a parent's right to participate in the case conference committee in developing a child's IEP, that in itself is enough for a court to say, you violated the idea. You did not provide FAPE, and then issue certain remedies against the school district. Now, what does that mean? How do you do that? Well, there's a number of ways that we can inadvertently exclude parents from decision making. One way we do that is through what's called predetermination. When we make a decision prior to the IEP meeting or the case conference committee about some aspect of the program or placement before we talk with the parents. That would be called predetermination. That's illegal. We can't do that. Now, let me show you. These are all critical procedural requirements. If we violate any of these are likely to be pretty serious. Sending prior written notice. You all know what prior written notice is. Anytime we change identification, evaluation, or programming for a child, we have to send a notice to the parent that we're doing that. Or if they request that we do something, we have to send notice to the parent that if we choose not to do it, that we are refusing to do that. And we have to give them our reasons why. Now, the whole reason for prior written notice is you have to give parents a chance to say, no, I don't want you to do that, or I disagree with you. But yet, if you look at compliance logs in virtually every state, one of the most frequent procedural mistakes made by school districts is that, sending prior written notice. So that's a very important procedural thing. And Another one is obtaining informed consent by the parent. So in other words, if you know before we do an assessment, the parent is sign on the dotted line. They have to agree to it. Before we place a child, the parent has to sign on the dotted line. We have to agree to it. If we don't get agreement and we place a child, we're violating that important procedural requirement. And that's probably in and of itself enough to say, school district, you violated the law. Ensure parents' meaningful involvement. That's the most important of all procedural requirements. And one of the most frequent ways we violate that is by doing something called predetermination. Making a decision before the IEP, the case conference committee, about what the child's education or placement is going to look like. There was just a case out of New Jersey where at an IEP meeting, the parents of a child with autism were told, we only place kids with autism in inclusive settings. We don't even consider other settings. Well, the parent wanted another setting, and they went to due process hearing and they won. Because the school cannot do that. You cannot say, we're going to do this with all kids. You can't make that decision until you get to the IEP meeting. Now, the school could have said, well, we prefer inclusive placements, and let's talk about that at the IEP meeting, and that would be fine. But by saying beforehand, no, we don't do that, you're predetermining. You cannot do that. Field an appropriate IEP team. It's very important that in that case conference committee, the law says you need to have a regular ed teacher, an LE rep, a special ed teacher, the general ed teacher. You have to have them there. That's not a list of suggestions. That means those are required members of the IEP team. And in a little while, I'll talk about a case called Deal v. Hamilton out of I think it was the 6th Circuit, where a school district was determined to have made the procedural error that led to a violation of the idea because FAPE was not delivered, because they did not include a regular ed teacher on the IEP team. And the court said, the circuit court, that's right under the Supreme Court, said that's a big error. That's a real mistake, and it violated FAPE. Determining placement only after the IEP is developed. You can't determine placement. The law has been clear on this since 1975. You have to determine what before you determine where. In other words, you determine your goals and objectives, your services, then you decide what's the least restrictive environment we can deliver these, but you don't do it the other way around. You don't start out by saying, we're going to place the child here, now let's figure out the IEP, because that is a procedural error. And then place students in the least restrictive environment appropriate for their needs. And we're going to be talking about LRE today, but you all know what that is. It essentially says that all school districts students have a right to be placed with non-disabled students when it's appropriate for their needs. And if not, we can move kids to more restrictive settings, but we have to go along this thing called the continuum of alternative placements. Now, I'm going to talk a little more about this, including parent participation in the case conference committee. This is the regulations to the Individuals with Disabilities Education Act. This is a federal regulation, which also applies in Indiana. This regulation says parental participation is so in the special ed process, decision-making process, from assessment to placement, is so important that it's one of the 2 procedural grounds for finding that LEA has been denied. LEA has denied a student a free appropriate public education. One of the 2 procedural grounds, and what I mean by that is if you look at this, like predetermination, that denies the parent's right to be involved because you effectively cut them out of involvement. Fielding inappropriate in IEP team, all if you don't have the parent. So these are all very important errors we have to be aware of. But the most important, as I said, is making certain your parents are meaningfully involved in the case conference committee. Now, I was a teacher in Minnesota, special ed teacher, for 16 years. And as you know, and I know, a lot of times it's really difficult to get the parents there or to get them involved. You have to make good faith efforts to get parents there. And Indiana requires, I believe it's two, or is it three? Three efforts. South Carolina, that's right. South Carolina's 2. You have to make 3 documented efforts using different procedures in order to get the parent there. If the parent's not there and you cannot be able to do it, and you can show that, you can go ahead with the IEP meeting. But otherwise, it's very important the parent be involved. Now, in this case I was talking about, Deal v. Hamilton, the court said parental participation must be more than mere form. It must be meaningful. And what happened in this case is involved ABA therapy for a youngster with disabilities, and they really had made the decision beforehand not to use ABA therapy. So the court said, in essence, they predetermined the placement, which made the parent at the team was just there for form. They didn't really have any say in the particular decision at all. So in essence, parent input must be based on understanding of what goes on in the IEP meeting, what's going to be discussed in the meeting, and what is being proposed. Now, that essentially means that as IEP team members, we, in case conference committee members, we have to take the parents' opinions and suggestions into account. Doesn't mean we have to agree with all of them. There was quite an interesting, sort of silly case out of Florida a few years ago, where it was out of Connecticut, where the parents in Connecticut had read on the internet how Dolphin Therapy was really important for youngsters with autism, and in fact requested an IEP meeting that the child be sent to Florida for this Dolphin Therapy. Well, the school district didn't agree with that, but what do you suppose they did? They discussed it with the parent. They talked about it and then said, well, we use research-based procedures and really not a research base to this, therefore we've decided not to do this, not to provide the Dolphin Therapy. So you can disagree with the parents. It's just that you have to give them a chance to give their opinion, to talk, to consider what they say. Now, there's an attorney from Texas named Jim Walsh, who all he does is defend school districts in FAPE cases and special education cases. And one of the things he always tells his school districts is that you need to keep good documentation in your IEP meeting in the form of notes taken at the IEP meeting. Now, some states require that, some states do not. But I have found in reading many cases that oftentimes FAPE cases turn on the notes in a meeting. Because there's a colleague of mine from Pennsylvania named Perry Zirkel who talks about the spaghetti strategy. And essentially what he says is attorneys will take everything they can and throw it up against the wall to see what sticks, like spaghetti. And what sticks is what they go with. And if they can convince a court that the parent has been constructively excluded, that will stick. The school district will quite probably lose a FAPE case. So one of the things Walsh has his school districts do is take notes in the meeting and then review them at the end of the meeting and have parents sign them. And he has a session I was attending a few years ago where he was talking about what good documentation looks like. I assume all of you probably take notes at your IEP meeting. We do in South Carolina too, it's just a requirement. It's not a requirement of our state regulation. But this is what Jim Walsh says about notes taking at the IEP meeting. Whenever you take notes, you don't want you want to write like Hemingway, short, succinct sentences on the big points. You don't want to be like Faulkner and just write free expression, take everything down. What you want to concentrate on are those really important points of the discussion. And he says always ask yourself the following question. If a due process hearing officer were to review the notes from the meeting, would that hearing officer be able to tell solely from the documentation that school district personnel kept an open mind and provided opportunity for parents to meaningfully participate in the IEP process? And remember, again, you don't have to agree. You just have to provide an opportunity to be involved. And then he gave a couple examples where he said things like, starting out the meeting saying, the purpose of today's meeting is to discuss the special ed services for Jeremy. The team discussed Jeremy's possible placements, the pros and cons of each. The chair asked the parents what alternatives they would like the IEP to consider in response to parental input. So, see, real short little sentences, but just really hitting the high points. That's very important. Like I said, I have read many cases in which the determination of the hearing officer or the judge has really come down to what's in the notes. So keeping good documentation is very important. So those essentially, that's the first part of the idea, the procedures. And remember, that's the first part of the Rowley test back in 1982. Did the school districts follow the procedures of the law? Now, second, it's very important to understand that this thing in 2014 I told you about called No Harm, No Foul. This is what it said. A decision made by a hearing officer shall be made on substantive grounds based on a determination of whether a child received a free, appropriate public education. In other words, in FAPE cases, of which the vast majority of most special ed hearings and cases are, the major question has to do with those what questions? The substantive requirements. What is in the IEP? Now, the substantive requirements are what the Endrew case was about, because that's the second part of the Rowley-Endrew test is, was the IEP reasonably calculated to enable the child to receive educational or to receive benefit appropriate in light of the child's circumstances. Those are what we call the substance or the what's in the IEP issues. And that's where school districts are much more likely to run afoul of the law than they are procedurally. Because procedurally, most school districts do a pretty good job. Substantively, that's a different issue. The substantive requirements of IDEA refer to the obligation we have to provide a free, appropriate public education that leads to student progress. The substantive requirements represent the what of special education. They represent what Julie Weatherly calls the content of the IEP. As a hearing officer, when I'm looking at a FAPE case or reviewing a FAPE case, I look at these two questions, the Rowley procedural question and then the Endrew substance question, because that's what the law requires that I do. And most importantly, I'm going to concentrate on the content of an IEP. Because remember, the Endrew standard is this: was the IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances? So what are these critical substantive requirements? These are really important because these are the requirements that school districts most likely have problems with. And these are just some of them. Conducting a current, relevant, and meaningful assessment that addresses all of a student's needs. That's important. All of a student's needs. That statement, irrespective of what the disability is, we have to address all of the student's needs. So if it's a child with learning disabilities, if they have behavioral problems, do we have to address it if they're not referred as emotional and behaviorally disordered? Yeah, of course we do, because that's the child's needs. Courts are not that concerned about what the disability category is. What they're concerned about is, did you address all of a child's needs? So that's number one. Develop your present levels of academic achievement and functional performance statements based on these current assessments that address all of the child's needs. Because the present level statement, very important, and we'll get more into that in a minute, but that statement represents the foundation of the IEP. And if that is wrong, it's quite possible that everything else in the IEP is wrong too. Third, we want to write ambitious goals that are measurable and then describe in the IEP how we're going to measure them. Very important. The measurable annual goals are crucial when we consider this new Endrew case. Why? Because the Endrew case says we have to have challenging goals. They have to be ambitious, they have to be measurable, and they have to enable a child to progress. If you have a goal that is not measurable, you can't show progress. That's why it's so important that we write measurable annual goals. Develop educationally meaningful services that address all of the students' needs. Connect present levels of academic achievement and functional performance statements to goals and services, and then make certain that we monitor student progress by collecting real data. And I'll talk more about that in a minute, because remember, that's what Endrew is focusing on, enabling a student to progress. We don't have data to show that a student did progress. We can't show progress. We can't meet the Endrew standard. Now, there's another area that we're seeing a lot more cases being found against school districts regarding what we could call the implementation requirements of the IEP. Because essentially an IEP refers, what implication requirements refer to is our obligation as school district personnel to implement the IEP we wrote. In other words, we could write the greatest IEP in the world, but if we don't implement it, we're probably going to be denying FAPE. So that's another very important piece. So implementation requirements essentially mean how faithful are we in implementing the IEP we wrote. And let me show you a sentence from a case just heard of the Ninth Circuit Court of Appeals called MCV Antelope Valley School District. According to the Ninth Circuit Court, which is right under the Supreme Court, they said the IEP is a contract. It is signed by the child's parents and the school's representative, and thus embodies a binding commitment. Now, so in some ways the IEP is a contract. It's a contract in the way we've said, we're going to deliver these services. We have to deliver them. But it's not like a contract because it's not a guarantee of success. The idea does not say the child is going to meet every goal. The child will succeed at the IEP. The IEP is not a contract in that sense. If the child doesn't meet the goal, that's not the problem as long as you're making good faith efforts. The problem is if you have things in the IEP that you don't deliver, that you don't implement. Now, the critical implementation requirements means we as LEA reps, as special ed teachers, as representatives from the on the case conference committee, must ensure that the IEP services are implemented in accordance with the IEP. If we say we're going to implement them, we have to implement. Okay? Also, that means we want to ensure that all the services, all the program modifications we wrote in the IEP are implemented as written, which that's very, very important. So if we look at all these things together, this is what we have. We have procedural errors that, not a good thing, but may not violate a FAPE. We have bad procedural errors and really bad procedural errors that if we make them on the case conference committee, we'll almost certainly be in violation of FAPE. And of course, those are predetermination, not involving the student's parents. That's number one. The second is the substantive errors. That's the what we write in the IEP. That's where the school districts are more likely to wind up violating the FAPE. And those are very important requirements that we understand. And then finally, we have implementation requirements. If we fail to implement a part of the IEP that's kind of a major deal, like there was just a case out of California in which math services that were the IEP had listed for the child were not delivered, and the court said that's a major problem. You said you deliver these services, you did not. That's an implementation error that leads to the denial of FAPE. Now, of course, this past year, and we talked about all of this already, 8th Justice of the Supreme Court in Endrew F. v. Douglas County School District essentially gave us this new standard, which is this. To meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make progress in light of the child's circumstances. So, what does that standard mean for us as case conference committee on the IEP team? Well, let's divide it into a couple sessions. First, let's talk about the assessment. This is what the Endrew case says about assessment. The whole purpose is to focus on the particular child. That's at the core of the idea. The instruction offered must be especially designed to meet a child's unique needs. And moreover, an IEP can only be, according to Endrew, can only be constructed after careful consideration of the student's present levels of performance, disability, and potential for growth. Now that is this is an important term, potential for growth, because I've not seen that in a court case before. That we have to think about in doing our present level statement and then writing our goals, we have to prospectively think about what is the child's potential for growth. That's not been there before. So in other words, the terminology here is in light of the child's circumstances. So even though Endrew said our IEPs must enable children, students, to achieve, to progress appropriate in light of their circumstances, they recognizes that these circumstances are going to be different for every child. And they didn't have a formula for figuring out, for hearing officers or courts to figure out if we did an appropriate job. That's up to us, but we have to make certain we consider the child's unique circumstances in writing the IEP, which means you address all of the child's needs. You then take those needs and you develop the IEP. You write your goals and objectives, develop your services, and they have to be developed with an eye to allowing a child to progress. Okay, in fact, now, there has to be a direct relationship between present levels of performance and the rest of the IEP, goals or services. I just reviewed an IEP, that I was talking about it before, a case in which a hearing officer's decision about FAPE was appealed. And one of the things the hearing officer did in this case is said that the school district had provided FAPE. But so what I have to do then is look at his decision, read all the evidence, look at the law and case law, and try and bring the two together. Well, the first thing I noticed when I examined the evidence box, the child's IEPs, is every one of his IEPs said the child had a math disability, had a learning disability in math. And lo and behold, I looked at the rest of the IEPs, and math was never addressed in the IEPs. So what I did was overturn the hearing officer's decision and say the school did not provide FAPE because they had addressed the child's needs in the present levels, but then they never addressed it anyplace else. So it didn't provide FAPE. So that's one very important thing. If you got to look at all the child's needs, and if there is a need, you have to make certain you address it. Now, needs always are addressed in services, but usually in goals too. So let me give you this was out of a question and answer document. Oftentimes when regulations come out, when the federal government issues regulations on the Individuals with Disabilities Education Act, which they did every time it's reauthorized, and a couple times more, they write regulations. One thing they do is they will put out a call in which they ask people to, if they have questions or suggestions, please send them to us. Well, there was a superintendent from Ohio in 1997 when the regulations were being issued, where he asked, what is the relationship between the present levels and the rest of the IEP? And this is what this is how the Department of Education responded to that. They said there should be a direct relationship between the present levels of performance and the other components of the IEP. Thus, if the present level statement describes a problem with a child's reading level and points to efficiency in reading skills, the problem should be addressed under both goals and specific special ed education and related services provided to the child. So in other words, when you find a need, you've got to address it in the rest of the IEP. To the extent that there's a need not addressed, you have quite probably have an illegal IEP. Now, here's what you need in your present level statement. This is what Endrew said about present level statement in essence. A student's IEP is constructed only after careful consideration of the student's present levels of academic achievement and functional performance, disability, and again, potential for growth. Moreover, the present level statement must identify all of a student's needs, doesn't matter what the disability is, identify all the needs, include an impact statement on how the disability impacts their involvement in general ed curriculum, and then we use that statement to develop goals and objectives. Courts have found that IEPs have been found invalid just solely because the present level statements were inadequate. So let me give you an example. There was a very famous case that's often other courts will discuss other cases. A case called Kirby v. Cabell County Board of Education. One of the reasons 2 years of a school's IEPs were declared invalid was because of the present level statements were not appropriately done. And here's what the judge wrote in the opinion. If the IEP fails to assess the child's present levels of academic achievement and functional performance, the IEP does not comply with the IDEA. This deficiency goes to the heart of the IEP. The child's level of academic achievement and functional performance is the foundation on which the IEP must be built. Without a clear identification of the child's present levels, the IEP cannot set measurable goals, cannot evaluate the child's progress, cannot determine which educational related services are needed. In other words, that is a substantive error that in itself can result in a denial of FAPE. So, the present level statement needs to identify students' needs. It needs to identify what the effect on general education is. It must serve as a baseline by which we can determine the rest of the IEP. Because as the Kirby court said, and goes on to say, the present levels are like the foundation of the IEP. Later on in the decision, he said, it's like a house. If you build a house on a faulty foundation, the house will fall. And that's essentially true of IEPs too. If the foundation's bad, everything else is bad. And then when you have a need, you've got to have it addressed in the rest of the IEP. To the extent that you don't, you have an illegal IEP. So that's where the assessment comes in, and why that is such an important part of the substantive requirements of the IDEA. Now, next we have annual goals. So when we have our present level statement, we have a baseline for where the child is. Now we have to write the goals. Okay, important to understand about the goals is Endrew said they have to be challenging. They have to be appropriately ambitious, and they have to address academic and functional advancement. So in other words, what Endrew is saying, and a lot of courts have said, is our goals have to be measurable, they have to be ambitious and challenging. Now, the emphasis Endrew really puts on challenging, that's very important. In fact, what the Endrew case said is they recognize that, we're going to have we have such great variety of kids in special education that we have goals for some kids that are a whole lot different than goals for other kids. Maybe kids with more severe disabilities, their goals are going to be a lot different for kids who have a mild reading disability, for example. But here's what Endrew says. I should say Justice Roberts wrote in the Endrew opinion. The goals may differ from child to child, but every child should have the chance to meet challenging objectives. In other words, what we need to do when we have our present level statement, we need to make a prospective guess, an educated guess of where we expect the child will be given an appropriate program in 1 year's time. And we write the goal for 1 year's time. One of the problems in the Endrew decision is the school district repeated the same goals for 3 years. That's like a red flag that the child is not progressing because you're keeping the same goals. So we want to be, reasonable in writing goals, but we want to be ambitious, because never, ever, ever have school districts lost for having goals that were too ambitious. When they lose FAPE cases, it's because they have goals that are not ambitious enough. Now, there was a case that went to the Supreme Court in the 1990s called Carter v. Florence. Thank you. It was a case that started in Little Florence County 4 in South Carolina. I passed, and it actually involved a young girl named Shannon Carter. Shannon was being educated at Timmonsville High School. Every time I go to Myrtle Beach, I pass Timmonsville High School. It's a nice big high school, but it's for a very small district, and every child from the district, most of them, go to this high school. And she was in 9th grade. She went to the high school. They wrote an IEP for her, and Shannon had a very severe reading problem. She was reading on a 4th grade level. Well, the IEP team met, and the parents said, Shannon has had an IEP now, but she's still reading in 4th grade. She's in 9th grade. So clearly, we're going to have to do something different to make certain that Shannon learns to read. Well, what the IEP team did is they wrote an IEP with reading and math goals that said Shannon will grow from 4.0 on a certain reading test to 4.4 in 1 year's time. In other words, she would make about a third of a year of reading growth on a standardized test in 1 year's time. The judge looked at that and said, those goals are meaningless. Those goals, this child is way below. She's reading in 4th grade level, or peers are reading in 9th grade. They're going up like that. She's kind of staying even. These goals are what he called inadequate. And this is what he wrote in his opinion. The stated progress on Shannon's goals in reading and math skills for an entire school year ensured the IEP's inadequacy from its inception. Even if Shannon had met her goals, she would continue to fall further behind her peers. The goals were totally inadequate. Florence County 4 district failed to provide Shannon Carter with a free, appropriate public education because the goals were so unambitious, that if Shannon had met them, it's kind of like, so what? She's still falling further behind her peers. Now, what that means is we want to avoid, caution sign comes up when you see unambitious goals, because like I said, courts are not worried about if a child doesn't meet a goal, or if a goal you write is too ambitious. What they're worried about is if the goal is too unambitious, so that meeting the goal will not do what Endrew says, enable a child to progress appropriately. And now you remember, we have all sorts of goals, and the students we work with differ so much. Goals will be different for every child. But Endrew says, regardless of what the disability is, they must be challenging and objective. Challenging and ambitious, I mean. So, in other words, when we develop goals, we need to remember a couple things. Number one, they must be measurable. And I know the IEP resource team and Matt spent a lot of time talking about the importance of writing measurable goals. Absolutely right. If your goals are not measurable, you cannot show progress. The Supreme Court requires that we show progress appropriate in light of a child's circumstance. That means you have to have a couple things. You have to have a baseline, that's the present levels, and then you write a goal that's ambitious, and you got to make sure it's measurable. Now, there are a number of ways people have wrote about how you write measurable goals, but I know three very important criteria for measurable goals are: you have to have a target behavior, something that's observable and measurable, like Jeremy will read 50 words a minute with less than 3 errors. You don't want a unobservable error. You don't want to have Jeremy will enjoy reading, because you can't measure reading. And yet I'll bet you see a lot of IEPs that are not measurable because they contain target behaviors that are not observable or measurable. You also have to say how it's going to be measured. So if I'm going to say Jeremy reads 22 words a minute, I'll say the goal might say when given a reading passage from such and such. So you have to say how it's going to be measured. I also have to say what is the criterion for acceptable performance. When will I know Jeremy has met his goal? So if he's reading 10 words a minute now and I project that he'll read 20 words a minute, that's my goal. 20 words a minute. That's a criterion for acceptable performance. Goal has to have at least these three components to be measurable. If it doesn't, it won't be. You know, and in research that I've done on IEPs, I've analyzed thousands of IEPs, and I can tell you most folks don't write measurable goals. And this Endrew decision really makes that important, that our goals be measurable. And by the way, when I started teaching, it wasn't required to write a measurable goal. That wasn't required until 1997, when the law then said measurable, they have to be measurable. Now, when you also, in terms of having measurable annual goals, what's the Article 7 say? You have to measure at a frequent and systematically during the school year, during instruction, and then you have to report the progress to students' parents. So and this is important, and it really dovetails exactly with what Endrew is saying. When progress reports and other data indicate that a student's annual goal is not going to be met, determine why you believe, using your expertise, that the goal is not going to be met, and then make instructional changes and continue to collect and report on the data. Remember, the idea is not really a guarantee of success. It's a guarantee that we're going to do the best darn job we can, which means monitoring regularly, frequently, using real data, and then actually making changes when instruction's not working. Now, a couple cautions. And one caution has to do with writing goals that are not measurable. Well, because Endrew says progress is the new way we have to measure progress. That's how we tell if an IEP is appropriate. If you don't have a measurable goal, if it can't be measured, you can't measure progress toward the goal. And this was stated real well in 2003 in a case called out of New Mexico called Rio Rancho Public Schools. IEPs, a year of an IEP was declared to be invalid by the state educational agency because the goals were not measurable. And here's what the judge wrote, or the hearing officers, I should say, wrote. The students' annual goals in each IEP simply did not contain objective criteria which permit measurement of student progress. A goal of increasing reading comprehension skills or improving decoding skills is not a measurable goal. An open-ended statement that the student will approve does not meet the law's requirements for a measurable goal. So that's why it's so important that as the IEP Resource Center is, they talk about this, and we talk about it at the conference, making certain your goals are measurable. That is going to really increase in importance under the Endrew decision, where the watchword now is progress. If we can't measure progress, we can't We can't show a child has made progress. Now, let me show you an example of a goal that was written in an IEP in Greenville, South Carolina. Now, they use graphs. All their teachers use graphs, which I think is the greatest thing in the world, because a graph is intuitively understandable. You don't have to know about percentile ranks and standard scores to understand a graph. Now, look at this graph. They had done a measure of reading ability called oral reading ability called words read aloud. They just asked a child to read for a minute, take a measure, and that is what they graphed. And what they did is they did a baseline, and they got 3 measures and wrote a present levels of performance statement down there. And that present levels of performance statement was in effect their baseline. Now, from that baseline, you need to project a year's growth. Remember, Endrew says, use their potential for growth and decide how far you're going to go in a year. Well, they knew, see that X there? That represented where the students' peers were in terms of reading ability at the beginning of the year, and they projected up here. Now, if I was a hearing officer and I looked at this, you could bet I would say, well, clearly they had present levels of performance, and that looks like it's a pretty ambitious goal because it lines up where the students are. I would say that is an indication of a good goal, because it shows clear progress in this trend line connecting the baseline to the goal, and it shows where his peers are. Clearly, that's a pretty impressive goal. And moreover, it was measurable. And in fact, as I'll show you later, the school was measuring it. So, in retrospect, these are what you need in your goals. Target behavior, how you're going to measure the goal, criteria for acceptable performance, and usually most school districts will have the timeline on there because it is for 1 year's time. But we have to make certain they're measurable, they're ambitious enough. Because remember, as Endrew said, a substantive standard not focused on student progress will do little to remedy the pervasive and tragic academic situation that prompted Congress to act in 1975 when they passed the idea. In other words, we need to be able to show student progress. We need to be able to show that we have developed an IEP that will allow the student to progress. If we don't do that, it's likely we do not provide FAPE. Now, the last area that Endrew really affects is progress monitoring. How do we monitor a student's progress toward the measurable annual goals? Well, we know that as IEP teams, as case conference committee teams, we must continually monitor and measure a child's progress toward their annual goals and maintain specific data to demonstrate that progress is being made. Or if progress is not being made, have data that demonstrates you notice that and you're making instructional changes and continuing to collect the data. So very, very important. Now, one of the things I was quite excited about when I looked at the brochure is that in a few weeks the IEP Resource Center is doing a presentation on collecting data. That is so important, because if we don't have data, we cannot meet the Endrew standard. That's what you need. You need to be able to show you have ambitious goals and you're collecting data to see if the child is on track to making those goals. Let's remember, one of the things that Endrew said that may wind up to be a real bane for special ed directors everywhere. Essentially what Endrew said is you've got to be able to justify your decision making. A reviewing court or hearing officer may fairly expect those school authorities to be able to offer a cogent and responsive explanation for their decisions that shows the IEP is reasonably calculated to enable the child to make progress appropriate in light of his or her circumstances. Think back to that graph. If I'm a special ed director on a stand and I'm asked, give me an explanation for why you think this is reasonably calculated to enable the student to make progress, show the graph. Here's where the child started. Here's where I expect the child to be. We think this progress is meaningful for the child, and we're going to be measuring it all along the way. Hearing officer would love you for doing that. But what they won't love is something like this. This was from a case out of upstate New York called Board of Education of the Rhinebeck Central School District. Involved an IEP that was determined not to provide FAPE. Why? Because the IEP was written in such a way in this particular school district that the goal was written, and then right next to it you had a line where it said, how do you determine if the goal is being met? And they had all these goals, and down the line for how you determine it's being met, it said teacher observation, teacher observation, teacher observation. That IEP was declared to be invalid. It violated the idea, did not provide FAPE, and according to the decision in this case, although subjective teacher observation provides valuable information, teacher observation is not an adequate method of monitoring student progress, because without supporting data, teacher observation is opinion which cannot be verified. That's it. Teacher observation without accompanying data, you cannot show progress. You can't say, well, you got to believe me, the kid made progress. No, you need to have data to show that a child made progress. There's an attorney who works in Texas named Kathleen Mayfound. I just heard her at a conference in Omaha a few years ago. She's an attorney with lawyers called Reed and Smith. She consults with legal research publications, and she defends school districts. And here's what she said, and this is before the Endrew case. This is even more important now that Endrew is law. She says that, and this is a quote from her, when I have a school district with a FAPE case, the first thing I do is go to the teacher and say, give me your information on your student's progress. And if the teacher doesn't have real data, I turn to the special ed director and say, settle, because you're not going to win this case, because you don't have any proof of a child's progress. And that is even more important now that Endrew says we need to be able to prove that our IEPs are reasonably calculated to enable a child to progress. So, data collection for progress monitoring. Remember, we should use graphs. They're really great ways to communicate data, but you need data. You need to measure frequently and systematically. In fact, the idea used to require that as often as general ed kids get report cards, that you collect data and report on it. They should be user-friendly and time-efficient. We can't be spending 2 hours a day on data collection. We have to have methods that are easy and quick and valid. And then we need to use those for instructional decision-making. Now, if we go back to that IEP from Greenville, this is what it looked like throughout the year. They not only had the baseline and they had the goal, but they continued to collect data on a weekly basis and then graph it. And could you imagine if a hearing officer would look at this and say, well, there was a goal, looks ambitious, and they're collecting data. It's measurable, real data, not opinion, that shows progress. You've got an unassailable IEP, a bulletproof IEP, because you can show progress. So the Rowley-Endrew test essentially says this, that number one, according to the Rowley test, we have to do the procedures correctly. Okay, we have to make certain that we follow the procedures, especially those really important procedures involving a child's parents. That's very important. Secondly, we have to write an IEP that have measurable and ambitious annual goals that allow a child to progress appropriately in light of the child's circumstances. And third, not up here, we have to make certain we implement the IEP as written. Okay, we have to implement those important parts of the IEP that we've listed, because in essence, the IEP is like a contract in that we have to implement what we said we did. Remember, it's not a contract and it's not a guarantee of success. It's just a guarantee that we're going to do the best job we can in delivering an appropriate education for a child. So, conclusions. Rowley requires we know and adhere to the procedures. Endrew requires we develop IEPs that actually enable the child to progress, measure, and be able to prove progress. And the IDEA requires that we consider the IEP as a contract. Now, what I'd like you all to do when you get home today is put these words, U.S. Department of Education and Endrew, into Google. And what you'll get is the U.S. Department of Education issue a question and answer document. This past December, in which they posed 20 questions, and 10 of those questions deal with what we need to do as IEP teams. And what it essentially does is it does the same things we've done today. It says the Endrew F decision is important because it informs our efforts to improve academic requirements for children. So it's essentially a question and answer document that goes through all these things we talked about today. I'd urge you to download it, read it. It contains really useful information. And it's from the U.S. Department of Education. So in the remaining few minutes, are there any questions or comments?